Thank you very much, everybody. And good afternoon and welcome to this Five Stone Buildings webinar on taking accounts. It's being presented by me and by Rose Fetherstonhaugh, whom you can see via this Zoom webinar platform. So it's being recorded and it will be available via a link on Chamber's website after the event for anyone who's interested but wasn't able to catch today's presentation live. We're going to aim to speak for no more than 45 minutes, so we'll try to deal with any questions at the end. You'll see at the bottom of your screen, there's a Q&A box. So if you are watching it live and would like to ask questions, please do so. If you prefer to remain anonymous, also please feel free to do so. Just indicate that when asking your question. So if we could move to the first slide, please, Joe. When we first advertised this talk, we got what I would describe as some perhaps rather anxious emails from some of you asking what it was likely to involve. I hope you will be reassured to hear that there will be no need in the course of this talk for you to get your calculator out or to resurrect your knowledge of double entry bookkeeping. The process of taking accounts is the mechanism by which the court can enforce a fiduciary's obligation to explain and to justify his or her dealings with the assets or the business with which he or she has been entrusted. The obligation of a fiduciary to account is sometimes said to be part of the irreducible core of the obligations which a fiduciary owes, is really central to her or his obligations. It's one of the hallmarks of being a fiduciary. So one of the things about this process of taking accounts is that it can arise in a really wide variety of different contexts. Wherever you have a fiduciary, you potentially have an action for the taking of an account. And the classic example, of course, is the trustees' obligation to account, but equally the principles apply pretty much in the same way to personal representatives. They apply to partners who obviously owe each other fiduciary obligations. They apply in a rather slightly quirky and distinctive way to the co-owners of jointly owned land. And they apply to agents as well. And in our court of protection practice, that means that deputies for property and affairs or LPAs for property and affairs can be called to account for their dealings with P's property. The claim for an account can be brought, and typically most frequently is brought, by the beneficiary, the person to whom the obligation is owed, or one of the class of people to whom the obligation is owed, by the principal in the case of an agent, or it can be brought by somebody who has stepped into the shoes of the fiduciary. So, for example, a personal representative can bring an action for an account against, let's say, a deputy or an attorney under an LPA who's previously acted for P, who's now dead. So asking for and taking an account from a fiduciary is really a subject of quite wide-ranging application and of some importance. But despite its importance and wide application, it's something of a niche topic, which is why we thought it was worthy of a bit of attention, not least because there are some sort of pitfalls and practical points which arise in the taking of an account, which are worth bearing in mind and which we hope to highlight during this talk. And I was trying to work out why accounts don't really get very much attention. Perhaps it's because typically they're taken by a master in the Chancery Division, now the Business and Property Courts, or by district judges in county courts or district registries. And of course, although things have changed, their decisions in the past, at least, used to be less reported than High Court judges' decisions. The claim for an account can be a freestanding claim, so you can bring it by Part 8 claim form asking for an account. But it's often also brought as a rather an afterthought on your claim forms. Just before your claim for further relief, you ask for accounts and other inquiries as a sort of catch-all, something to be picked up at the end as one of the consequential matters that get dealt with at the end of a long trial. So it can be round 2 or even round 3 and 4 in long litigation. I should explain the tennis balls, actually, sorry, that they're a homage to what perhaps we might all prefer to be watching at this time of year. I wish I could promise that Rosie and I could provide a similar level of excitement and drama for the next 40 minutes or so, but we'll do our best. And so with that brief introduction, I'll lob it over the net to Rosie to take the next couple of slides and to explain in a bit more detail the sort of different senses in which the word account can be used in this context. So next slide, please, Jo.
Thanks, Sarah. I really wish you hadn't said that, because notwithstanding numerous tennis lessons when I was younger, I'm still incredibly bad at tennis. So hopefully our volley won't be as bad as it would be if we were actually on courts. But anyway, so starting with the fundamental question, what is the obligation to account? Now, Sarah's already hinted at it, but at its core, the obligation to account is really about the duty to provide information in relation to the assets. Often we're talking about trust assets, but not always, and what the trustee or other fiduciary has done with those assets. So the trustee, I'm going to use the example of the trustee because that's what we usually find as private client practitioners. The trustee must be ready to explain to the beneficiaries, or sometimes the other trustee, what has happened to the fund at any given time and the transformations it has undergone, whether it's been sold or expended and so on. And the relationship of accountability is fundamental to the fiduciary relationship, because it allows the beneficiary to play watchdog and check up on what has happened to the assets. Now, on the slide, you'll see that there are 2 phrases in red. You have first provision of information and then remedy. And they indicate the 2 aspects of an account, or, well, 2 of the aspects of an account. Because while an order for an account in the sense of the provision of information can be described as an equitable remedy, what you're really talking about here is that in making the order, the court's not granting a remedy for a wrong as such, but enforcing performance of the trustee's obligation to account. However, once you've got past this provision of information stage, an account can often give rise to a remedy for a wrong, and this will arise from any defects or issues with the explanation that's been given. So in this way, an account can often act as the springboard for proceedings to recover trust property that's gone walkabout, or personal remedies against the trustee, for example, for breach of trust, and will often conclude with an order for payment in respect of, say, expenditure that the trustee should not have incurred. There's also an important distinction highlighted on the slide between taking an account in common form and taking an account on the footing of willful default. This is a bit of a trap for the unwary, because as Sarah will come on to explain in relation to later slides, you have to explicitly ask the court for an account on the footing of willful default. It won't just be awarded to you. So what's the distinction? In very brief terms, when you're talking about taking an account in common form, you're holding the trustee to account for what they've actually done with the fund. So you're looking at investments that the trustee has made or expenditure that they've actually incurred. But when you're looking at an account on the footing of willful default, you're looking at what the trustee should have done but did not in fact do. So an example of this might be if the trustee has failed to bring a claim against a third party and limitations expired, or if they've failed to sell a property at market value and you're saying that they should have got more for it than they did. Could we have the next slide, please, Jo? Thank you very much. So, step 1, getting an order for an account. Now, as the slide says, the relevant procedure on an account when you're in the business and property courts is CPR rule practice direction 40A. You can also refer to chapter 23 of the Chancery Guide. Although it is less than a page long, it doesn't give you much. So possibly you can see how important that the author thinks accounts are in the business and property courts. Moving on to the next point down, orders for accounts that are generally made in an early stage of proceedings because they're the first step in what can often be a fairly drawn out process. It is a pretty low threshold for obtaining an order for an account. And a full trial with oral evidence shouldn't generally be necessary for that purpose. Now, there's a very recent authority called Ball and Bull, which Sarah is going to speak more about in later slides. And Chief Master Marsh made some quite useful comments about oral evidence in this regard. In essence, he doesn't particularly approve at all, and doesn't consider it necessary for there to be protracted or indeed any cross-examination when you're looking at this threshold point about getting an order for an account, especially in acrimonious family disputes. Because something that Sarah will discuss is that accounts are incredibly expensive, and obviously we all want to do our best to avoid costs where possible. Having said that there is a relatively low threshold for obtaining an order for an account, there are a few hurdles that it's important to consider before making a claim and when you're advising your client about the possibility of making one. So we've summarised 4 on the slides. The first and most obvious one is, well, is there a fiduciary relationship? Because if there isn't, then obviously that's quite a big problem. A more difficult point is limitation, which is quite fiddly when it comes to accounts. Limitation may provide a basis for not ordering an account, or even if an account is ordered for the reasons we'll discuss later, may put a spanner in the works as regards recovery or any later claims. So the relevant section is section 23 of the Limitation Act 1980, which provides that an action for an account shall not be brought after the expiration of any time limit applicable to the claim which is the basis of the duty to account. Sorry, that's a bit of a mouthful, and I'm sure you'll all want to go and read it in close detail later. But in essence, section 23 suggests that the duty to account is always parasitic on some other cause of action, like a breach of contract, and will be barred when time has run out on that cause of action. However, it is clear from the authorities, including a decision called Henchley and Thompson, which comes up later in the slides, that section 23 does not apply to a claim for an account based on a trustee beneficiary relationship, that is your garden variety common form account. Because in such a case, the beneficiary is entitled to enforce the obligation owed to him or her by the trustee on the basis of their relationship. Now that's the distinction that I mentioned earlier between a positive order enforcing an obligation that the trustee owes to the beneficiary to provide them with information, rather than a remedy for breach. However, notwithstanding that section 23 does not apply in these circumstances, you still have to consider things like late fees, acquiescence, although generally these will just be general considerations relevant to the court's discretion in deciding whether or not to order an account. So what does section 23 bite on? Now what it does bite on is the remedy stage, that is on any claim underlying the claim for an account. So if you've made a claim for an account on the footing of willful default based on a breach of trust, and the breach of trust is statute barred, then the court is not going to order the trustee to pay up in those circumstances. And that is something to be thrown into the mix when considering whether the court will exercise its discretion to order an account in the first place. Moving on to the third point, that's fairly self-explanatory. The court will consider whether a sufficient account has been given, and if it has, there's no reason why it would exercise its discretion to order a further account. Fourth, and relatedly, the court has a discretion whether or not to order an account, which we're going to talk more about in a few minutes. Thank you, Joe. Please could we have the next slide? Over to Sarah.
Me, back across the net. Yeah, so I'm going to look a little bit more about the third point on the last slide, what amounts to a sufficient account or explanation. And the first point, as I think we've made clear, is that the fiduciary should be ready with his accounts, because being obliged to account is part of his fundamental or her fundamental duties of being a fiduciary. So a fiduciary will be expected to be able to explain what exactly he or she has done with the trust property, and furthermore should retain the documentary evidence to prove or vouch for that account. And if unable to do so, then the court can presume facts against the fiduciary. So, for example, this can lead to a fiduciary having to restore to the trust fund expenditure which he or she has incurred, but which, because of the lack of documentary evidence, can't be justified. And so if you look back at some of the sort of Victorian cases in this area, you might have the impression that a fiduciary who's not able to produce a sort of beautifully, carefully balanced set of books is therefore in pretty deep trouble. And, you know, that can be true, but certainly the modern approach takes into account the context in which the fiduciary is operating much more in working out what is a sufficient account. So, for example, it will take into account whether or not the fiduciary is a professional or a lay person, whether the absence of documentary evidence is reasonably explained by the lapse of time, and in particular, whether objectively there's going to be anything to be gained by imposing on the fiduciary an obligation to provide a further explanation or more information than has already been provided. And it's important to remember what I've highlighted on the second bullet point there, which is, although we may all envisage a set of accounts with columns and figures and headings, and indeed that's often what is reasonable to expect, there isn't actually any particular form which is required for an account, provided that it conveys the necessary information. So there are a couple of cases recently, which I've mentioned at the bottom of the slide, where the court has actually declined to make an order for an account because the fiduciary has already provided what the court deems to be an adequate explanation. They're both decisions of Chief Master Marsh. The first is Ball and Ball, where the account was refused outright, and I'll come on in a moment to talk about the facts of that a little bit. Henchley and Thompson was a case where there was a claim for an account in respect of two trusts, and the court declined to make an order in respect of one of the trusts on the basis that there was nothing to be gained from asking for further information, but did make an order in relation to the other trust. But I'll just look in a little more detail, if I may, at the facts of Ball, which was a case in which I had some involvement at an earlier stage than this final hearing. So sadly, as I'm sure a situation which will be familiar to all of you, it was three siblings who'd fallen out with each other after the death of their parents. Their father had died in 1978, leaving his estate on trust for his wife for life, so she was entitled to the income for life, and then for his three children, Jonathan, who was the claimant, Christopher and Jennifer, who were the defendants to the claim. And all three of them were trustees of that trust. So father had died in 1978. Their mother, Dorothy, died in 2016, and her will left her estate in slightly unequal shares, giving the claimant slightly more, which was a fact which led to the claimant having an incentive to challenge the dealings with the father's will trust. So one of the main assets of the father's will trust was his shares in a family company in a department store in Cornwall called Rose. And Jonathan effectively complained that he, although having been appointed a trustee, had been excluded from trusteeship, any active involvement in the trusteeship, and had been excluded from the running of Rose. He'd taken a different career path. So he brought a claim for an order that his siblings should account to him for their dealings with father's will trust. Now, in some ways, this was quite a surprising application to make, because, as I've said, he was one of the three trustees, and he was in a position at all times to call his or to involve himself in what was going on with father's will trusts. But as I've said, he thought he'd been excluded from the practical operation of the trust and wanted an account. But Master Marsh declined to make such an order. And in particular, although there were gaps in the documentation which had been produced since 1978, he found that the defendants had provided a sufficient account to the claimant, in particular by responding in a very detailed way to his letter of claim pre-action, attaching a relevant summary of income received and paid and assets of the trust. And in declining to make an order for an account, even though there were some sort of documentary gaps, Master Marsh was clearly influenced by the fact that this had been a small family trust with a limited class of beneficiaries. All of them had been adult. They had, none of the parties involved was professional. The claimant himself was a co-trustee, so as I've said, was in a position to investigate matters earlier if he'd chosen to. And the account would have involved an examination of material going back for 38 years or more. An unattractive starting point for the claim. Could we have the next slide, please, Jo? And as Rosie's mentioned, though, I mean, both Ball and Henchley are worth looking at in terms of setting out really the principles which the court will apply when deciding whether or not to make an order for an account, and what the court will consider is, in context, a sufficient account or explanation. And the first point is that when you come to ask for an account in terms of provision of information, you don't need to show that there's been any breach of duty. All you need to show, subject to the exercise of discretion, is that there hasn't been a proper explanation so far. So no need to show breach of duty at this stage. What's an adequate account? Well, the second bullet point there contains a quotation from Henchley. The trust accounts must be able to show from period to period how the trust assets have been dealt with, including what distributions and disposals have taken place, whether the trust assets conform with the trust instrument. That effectively means whether or not the investments are authorised or within the category of investments which are authorised by the trust instrument, because the trust instrument might, for example, preclude you from investing in certain investments, and that the class of assets held is appropriate. So you need to know, has there been a diversification of the fund, facts like that. So at a minimum, the accounts have got to show what assets there were, what the fiduciary's done with them, what the assets now are, and what payments out have been made. That's the bare minimum, but the level of detail and formality required is going to vary depending on the size of the fund and the nature of the trust. What's adequate from a lay trustee of a small family trust might well not be adequate from a professional trustee of a large pension fund. So back over to Rosie, who's going to talk a little bit about discretion and then start on the sort of practicalities of the taking of an account. So next slide, please, Jo.
Thanks, Jo and Sarah. Okay, so moving on to discretion. As the first quotation on the screen makes clear, it's important to recognise that the duty to an account and the entitlement to an order from the court are distinct. So there's no absolute entitlement to an order for an account. That was decided by Master Marsh in Henchley after counsel had argued that, in fact, they were tantamount to the same thing. And once you'd established an obligation to an account and no release, there would always be an order. But I think knowing that we have a discretion, it's obviously very important to understand the sort of circumstances in which the court will exercise its discretion and when it won't. Because it looks like from the authorities that the circumstances are going to be pretty limited when the court will refuse an account, especially in what are referred to as conventional trustee-beneficiary relationships. So when you have an express trust with trustees and beneficiaries. For example, pleading a long delay, for example, in asking for the account will not necessarily assist a trustee, because the beneficiaries need to know what has happened to the trust assets, and the fact that they've delayed a number of years in asking the court to make that order is not necessarily an answer. This will especially be the case if you have succeeding generations of beneficiaries, as you often do with dynastic family trusts, who may not know what's happened to the trust assets in the past, when the older generation were the principal beneficiaries of the trust. So, having said that, when might the court refuse to exercise its discretion? First, the notion of an account being oppressive pops up in the authorities. Oppressive replaces the earlier term in some of the older authorities of an account being used as an excuse to blackmail a trustee. Now, Master Marsh didn't think that this term, blackmail, was terribly helpful. But what he did say is that it might be oppressive to order an account where, for example, as Sarah said, records have been destroyed for an inexplicable reason, I must add, rather than simply having been mysteriously lost in a flood or a fire or something like that. Or another example of where it might be oppressive to order an account is where there's been some acquiescence in the way that the trust has been administered. So if beneficiaries have gone along with the trust being administered with fairly informal records, it might be considered oppressive for them to then come along and say, well, excuse me, I would like some formal accounts detailing exactly what's happened to every penny and pound for the last 16 years. Secondly, the court might refuse to exercise its discretion because it might consider it to be unnecessary to make an order for an account. This will tie into the question of whether a sufficient account has already been rendered, but it may also be that the beneficiary already has sufficient information to bring a claim for breach of trust, for example, and therefore does not need an account. This was a point that Master Marsh did not expressly need to decide in Ball, because he refused to make an order for an account, but he did comment that the claimant had already had the relevant information in his possession for at least 2 years if he wanted to make a claim. Finally, the court may conclude that it might not be fruitful to order an account because any underlying claim might be statute barred. And that's what was discussed in Al-Dawaisan and Al-Salam. However, this point does have to be qualified. Al-Salam was a business dispute, but when we're talking about conventional trustee-beneficiary relationships, this issue of the account being fruitful in terms of an underlying claim might not assist the trustee so much. Because while it's all very well to talk about limitation in relation to a business dispute, where there's a conventional trustee-beneficiary relationship, the provision of information will often be an end in itself, because in essence, the beneficiary is entitled to know what's happened to the trust assets in which they have an interest. So in that context, it is unlikely to be a conclusive answer for the trustee to say, look, terribly sorry, but any breach of trust claim is barred. And while there's not a presumption in favour of an account, it would be pretty unusual for the court not to exercise its discretion to make an order. Thanks, Jo. Could we have the next slide, please? Thank you. So now we come to the bit of the court process where the trustee is actually giving an account. As I mentioned before, this is governed by the procedure in Practice Direction 40A. And it's the stage before the beneficiaries raise any specific objections they might have. So what would usually happen is the trustee gives their account and verifies it with an affidavit or witness statement and essentially exhibits the account, whatever format it might be in, to that witness statement or affidavit. And so below we have this issue about the fiduciary's obligation to vouch, i.e. retain documentary evidence for their dealings. Now, fiduciaries undoubtedly have a duty to keep and retain records of their dealings with trust property, But this comes back to the point that Sarah was making in relation to whether or not a sufficient account has been rendered, because the duty to keep records is not determinative of the sort of account that has to be provided. As Sarah said, the account may be given with formal financial statements, less formal documents, or none at all. And there are authorities where the court has accepted a narrative explanation rather than an explanation on the documents of what has happened to the trust assets. However, obviously there are caveats as ever, and this will depend on things like the nature of the trust assets, the reasons for the records being unavailable. Is there a legitimate reason why they're not available? And it's also inevitable that professional trustees will be held to a higher standard than lay trustees in this regard. And it does seem likely that the court will come down pretty hard on a professional trustee who has kept inadequate records of their dealings with the trust assets. Now, Sarah is going to discuss step 2. So could we have the next slide, please, Jo?
Right, so you've got your explanation, but that's really only the beginning of the fun. The next stage is to pore through the account and the supporting documentation to compare it with the documents that you have in your own possession and you may have in your own right, and try to identify the gaps and discrepancies to work out whether or not there are aspects of the explanation that you challenge. And in particular, you'll be looking for assets that you think the trustee or fiduciary has received but hasn't shown in his or her account. You'll be looking for assets which you think that the fiduciary ought to have realised but hasn't. You'll be looking for payments out which aren't justified. So, for example, payments to the wrong beneficiaries, or payments for trustee expenses which don't stack up. You'll be looking, finally, for what I call bad investments, or investments such as a failure to realise property at full market value, or failure to exercise proper care in the investments that have been made. So you'll be scrutinising all those points and working out whether or not you want to challenge the account, which is in effect to say some of this should be disallowed, or the trustee should bring into account assets which don't appear on his explanation. So here's where there is some sort of linguistic precision required and some differences in principle to be drawn out. You'll come across the terms falsifying the account and surcharging the account. Now, falsification of an account is when you want to challenge outgoings. So you want to say that debits to the fund shouldn't have been incurred. In that situation, you're seeking to falsify the account. So you're looking at what's going out of the fund. When you surcharge the account, you are saying there ought to be more money there, or more assets there than show up on the account. You want to say you're challenging effectively the incoming side of the account. You're surcharging it. And there's an important distinction in principle between these two things, because the burden of proof of showing the legitimacy of outgoings is always on the fiduciary, and the obligation of showing that more should be there than is shown is on the beneficiary, or the person bringing the account. And then the next distinction is one which was alluded to in one of the earlier slides, the difference between an account in common form and an account on the footing of willful default. Essentially, if you want to say that of the fiduciary, you should have received more but for your breach of duty, you need a specific order from the court which says that the account should be taken on the footing of willful default, or at least aspects of it be taken on the footing of willful default. An account in common form limits you to challenging the trustee's account of what he's actually done with the fund, whether the expenditure he's incurred is authorised or not. So that's a procedural tricky that can catch the unwary out. And I'll look at the process of getting an order on the footing of willful default on the next slide, please, Jo. So the procedure when you're challenging the account, well, the court will often lay down specific directions for how it should proceed, but in the absence of those directions, look at practice direction 40A, and in particular paragraph 3 of that practice direction says that if you, having received the account, wish to object to any form of it, you must give written notice of that objection, setting out effectively the grounds of your objection, what you say ought to be shown in the account, and why you say that, and support that by a statement of truth. And then what will happen once you've given your written notice of objection is that the court's likely to list a hearing at which it will give directions in the normal way for case management. And it may order the parties to put in points of claim and points of response, and it may give directions for the exchange of oral evidence, because at this stage, it's not just the threshold question of are you entitled to an account, which Rosie mentioned earlier. You're now sort of specifically challenging what the fiduciary has done with the assets, and you're likely to want to cross-examine him or her about that. You might need expert evidence if you're saying that there are bad investments. And as I said previously, if you want to say there ought to be more here, because of some breach of duty by the trustee or fiduciary, you need to be seeking an order that the account be taken on the footing of willful default. Just 3 points to note here. First is the language of willful default is unhelpful because it crops up in another area of trust law, which is in relation to exoneration clauses, exemption clauses. In this context, taking accounts, it doesn't mean dishonesty or deliberate breach of duty. It just means any proven breach of duty. I've explained why you need it. You need it in order to be able to bring in assets or value which ought to have been collected but hasn't been because of some breach of duty. And you need to show some clear breach of duty in order to get that order in the first place, because what it does in principle is open up a wide-ranging inquiry potentially into all aspects of the trustees or fiduciaries' administration of the assets. So you've got to show one instance in order to be able to show that there's a real reason to think something in general has gone wrong with the administration of this trust. So I think we're going on to the next slide, which is, please Joe, what I called the final reckoning.
The strawberries.
The strawberries. This is the end of the process, the fruits of your endeavours. You'll have gone through the process of examining, challenging the accounts, receiving the response, cross-examining your errant fiduciary. And at the end of it, the court should determine which of your challenges are upheld. It will disallow expenditure if it wasn't authorised. It will surcharge the accounts with amounts that ought to have been received by the fiduciary if you've got your order on the footing of willful default. And ultimately, it'll come up with a figure which the fiduciary is liable to pay. Now, depending on the nature of the relationship, the fiduciary may be liable to pay the beneficiary outright, or what may be in question is restoring to the trust fund the value which ought to be there but isn't. And I put a costs in question mark here because there are no special rules as to the costs of taking accounts. The general rules apply in Part 44. But 2 points are probably worth noting. The first is that although trustees and PRs and other fiduciaries are in general entitled to an indemnity from the fund for their costs, if they've been found to be liable on the taking of an account to restore money to the trust fund, they're very likely to be disallowed their indemnity. So they're at personal risk on costs of this procedure. And then the other point to note is that given taking an account involves, by its nature, sort of going through various little issues or big issues, but discrete issues, there's much more scope for the court making a partial costs order or an issue-based costs order at the end of it. So that really makes it very important to make a considered Part 36 offer or some other costs protective offer at an early stage in an accounting process. And it should provide, it doesn't always provide, a useful disincentive to arguing about very disproportionately small amounts. So now we're going to look, Rose is going to take us through an example which hopefully demonstrates some of these principles in action. Next slide, please, Jo.
Thanks, Jo. Okay, so I'm just going to read out the example. Nureyev is a busy solicitor. He has acted as trustee of the Black Swan Trust, which contains substantial funds, for 20 years. The life tenant Margot has just died. Nureyev had a very good relationship with Margot, and she was happy with the informal way in which he ran the trust while she was alive. Oh dear. However, Margot's children, Darcy and Marianella, who are also beneficiaries of the Black Swan Trust, are now taking issue with the way things were run. They say that Nureyev did not keep sufficient records of what was done with the trust funds. It also looks like the trust made various unsecured loans to Margot, even though she was not a capital beneficiary, as well as to companies controlled by Margot, and sold us some trust property at an undervalue. Could we have the next slide, please, Jo? Thanks. Unfortunately, Margot's estate is insolvent, so there is no prospect of the loans being recovered. And to add insult to injury, Nureyev has not taken any steps to recover any of the company loans, some of which may now be statute barred. So, next slide, please, Jo. Darcy and Marianella instruct Covent and Garden LLP to write a pre-action letter to Nureyev. He responds with a very apologetic 18-page letter setting out what he remembers of the administration of the trust over the last 20 years, together with some bank statements and email correspondence recording the decision to make some of the loans to Margot. He says that there were formal loan agreements with the companies, but he can't find them. Darcy and Marianella are not satisfied and issue a claim for an account in common form. Could we have the next slide, please, Jo? So, what happens next? Now, I got a bit carried away when I was drafting this example, so we're not going to have time to go through all the issues that arise in relation to it, but dealing with some of the points on this slide. First, logically, has Nureyev given a sufficient account? Now, we don't know what he said in his extremely lengthy 18-page letter. I don't know whether it was single or double line spaced. But I'm going to take a punt that he has not given a sufficient account because he has failed to show in sufficient detail what transformations the trust property has undergone. As we mentioned earlier, the information has got to be presented in a way that can be interrogated by the beneficiaries. And it seems from the gaps that we know about that the beneficiaries are simply not going to be in a position to ascertain, for example, what's happened in relation to these loan agreements, because he simply said that he can't find copies of them. And frankly, the court's likely to conclude that that's not good enough. As a professional trustee, he's going to be held to a higher standard than the lay trustee. The trust fund is large, so it's more critical that a proper and formal account is given. And there are beneficiaries to whom it appears Mr. Nureyev has not really paid any attention during the lifetime of the life tenant, who importantly was not a capital beneficiary. So any acquiescence by her in the way in which the trust has been run will not really be relevant to what Nureyev has done with the capital, i.e. he's been making loans that he's not bothered to call in. I don't know whether you would agree with that, Sarah.
Really, no, I don't think, looking at the facts, that Nureyev is going to be let off the hook simply by writing a long, probably rambling letter. An important fact here is not only that he's a professional, but, as I think you mentioned, Margot was never the sole beneficiary of this estate, so he ought to have had in mind that Margot's sort of going along with things was not going to protect him, and have an eye to Daniela, the beneficiary at the end of the day. And willful default is definitely something they should be considering pursuing, because there are various aspects, aren't there, of the investments which don't produce the return for the estate. So the sale at the undervalue, the failure to collect in the loans, that sort of thing is a sort of classic willful default avenue.
Yeah, and of course it wouldn't really be open at this stage to the beneficiaries even to be able to make a claim for breach of trust in that regard at this stage, because, for example, they don't know whether the loan agreements contained any provisions for interest, say, because they simply haven't been provided to them. So I suspect the court's not going to be terribly sympathetic in that regard, and I think it's almost certain that the court would order an account, wouldn't you agree?
Yeah, absolutely. And there's no sort of limitation problem because their interests didn't vest until Margot died, didn't vest in possession. So I don't think there's any prospect of his relying on the lapse of time.
Yeah.
So I think we're that's our. There's quite a lot of meat to that particular story, but I think notwithstanding what we were saying before about the circumstances in which a court might not order an account, Nureev's situation is not in the category of cases where a court's likely not to make an order for an account, and there's plenty there to be explored and challenged in due course. It looks like we could be kept busy with it for some months, if not years to come. Can we have the next slide, please, Jo? Just a salutary warning, I think we've really touched on this before, but there is a real risk with the process of taking accounts that if every single little point is interrogated and challenged, it becomes a very expensive procedure. And I've taken this from the Chancery Guide in relation to partnership claims, but it's equally, I think, true of accounting in relation to estates and trusts as well, that the expense of taking an account may end up being disproportionate to the amount at stake. And so it's always worth considering and exploring other ways in which it can be resolved, such as by mediation. You should also focus quite carefully on what really is at stake financially and discourage your clients, in my submission or suggestion, from pursuing really small points which may be important to them as a matter of principle, but which financially are not worth pursuing and will expose them to costs, risks if they lose. And again, as I said before, making sensible offers to settle at an early stage will give whichever side you're on some costs protection. So we've got a few questions, Rosie, if we want to have a look at those. First question comes from Mauritius, from Rafiq, and he asks whether there's any prescribed time period for which trustees are required to retain trusts, documents and records. And the answer to that is actually really no, there is no time period, so they'd be well advised to keep files for as long as the trust is still in existence. And so you can't say that there is a claim or time period beyond which the claim could not be brought. Now, we're asked a question by Michael Henry, a very good question, about what the costs of taking an action for an account might be. I think you've got to distinguish between two aspects really here. One is the initial action for the provision of information, which is quite a cost-effective, low-cost piece of litigation, because as Rosie said, the threshold's pretty low. You probably don't need to have any oral evidence. The court will normally make an order for an account, the provision of information, at a fairly early stage of proceedings. So that stage is fairly low cost, and even in a low value estate, it's worth pursuing. The taking of the account or the challenges to the account, I think it's really very difficult to say, even in ballpark terms, what that might cost, because it really does depend on how many items there are of challenge, what their value is, whether what's involved is going to require expert evidence or not, how many witnesses you're likely to have. But you're going to be talking of tens of thousands of pounds and possibly, into six figures in the worst case scenario. I don't know whether you've got any thoughts on that, Rosie.
Well, yes, there was a trial for an account that I ended up doing. I'm sure Sarah knows the one to which I'm referring.
Yes, I know.
Where proceedings had been issued in 2014, and the trial came on in I think it was November 2018. So 4 years for the proceedings to be on foot. There were 26 narrowed down issues for the court to decide, a High Court judge. Some of the issues were worth £352. And overall, it was incredibly, these things can run into the hundreds of thousands of pounds. And I think that's why Sarah says that it's very important to be aware of the costs running up in this sort of action, because you really need to be able to see the wood for the trees, I think.
So I'm afraid we can't give you a figure, but it can be extremely expensive in the worst sort of accounting dispute. Where trustees are or were married to one another, might that affect the court's decision to order an account? Lisette has asked. Well, it depends. Yes, I mean, it depends who's asking, I suppose. I mean, if it's one of the married parties, i.e. one trustee seeking to require the other trustee to account, it might be relevant, the fact that they were married and, for example, allowed each other to administer the trust in a particular way. I mean, if you're looking at a third party beneficiary asking the married couple to account, I think they're both likely to be ordered to give the account, albeit maybe one of the married couple was more responsible for managing the trust, and therefore it might be expected to provide more information than the other. So it might affect depending on the circumstances. And then someone finally has asked, can you ask for an order for account in common form and willful default in the same Part 8 claim form? Would that be considered too wide? Well, what you have to do in order to get your order for willful default is establish at least one clear case, ideally a pattern of breaches of trust. So you will want to plead that and identify that, and your fallback position could be to ask for an account in common form, because one thing the court could do in the course of making its order is order that an account be taken on the footing of willful default for some transactions and not for others. So the court might decide to say, well, I can see that this land was sold at an undervalue, and I'm going to make the trustee account on the footing of willful default for that, but I have no evidence to suggest that there are any other transactions out there which are questionable. And so it would be wise to sort of cover your bases in that way. But to get the order on the footing of willful default, you are going to have to identify and prove at least one instance, and ideally more, of breach of duty. Yes. Now, James Lister has asked a very good question. If you're bringing an account in common form, the claimant then takes the risk that ultimately he's not going to get anything out of it because there could be a limitation defence. And I think that's a point that Rosie made before. Yes, unless you could persuade the court that there's no limitation defence at all, because all you're doing is preventing the fiduciary from saying that he spent the money in a particular way, and I don't think that's likely to wash. Yes, I agree that the provision of information may do you no good if ultimately your attempt to challenge the account that he's given is doomed to failure because of limitation.
Yeah.
So, does that answer it, Rosie, do you think? Or?
Yeah, I think so. I mean, I suppose there may be a rare occasion when a trustee does not take a limitation point, but yes. Because I suppose it's only a procedural defence limitation. So I suppose there could be an event where the trustee doesn't plead it, but I would have thought that would be pretty rare.
Pretty rare, but yes, and then it maybe you can find a beneficiary out there whose interest hasn't vested, and so you can say that there's no limitation defence, or maybe the trustee has used the money for his own purposes, so there's no limitation period for that reason. So there are, I mean, the whole area of limitation and trusts is incredibly complicated.
Yeah,
and worth a seminar in itself.
Exactly. Section 21(3), isn't it?
Well, thank you very much, everyone, for listening. As I say, there will be a link to this after this seminar is concluded on our website. If there's anyone you think might be interested in catching up on it afterwards, please do mention it. But we're going to sign off now, so thank you again and goodbye.